Okay, great. I think that's a good number of you. So welcome to Garden Court's webinar, Going Forward, the Public Sector Equality Duty and Housing Law. Just to start with, I'm sure we're still waiting for a few more people to log on, but the webinar is scheduled to go from 5 tonight until about 6:30 this evening. If I could ask all attendees to use the Q&A box during the webinar, and we'll take all your questions at the end. If any of you have a burning desire to speak, we can unmute you and turn on your camera at the end, so you can ask your question to our panelists in person. It is being recorded, and the slides and recording will be circulated. So if you miss anything or have to log off, that resource will be available to you. Just a few other webinars that we've had going on recently. If you missed our two-part webinar series on domestic abuse and housing, which we held in honor of International Women's Day, that's now available on our YouTube channel. And in the chat, we'll be posting the private link to the Garden Court Housing Team's YouTube playlist, so you can watch that. We had some incredible guest speakers in that series, including Rebecca Goshawk from Solace Women's Aid, Izzy Mulholland from the Public Interest Law Centre, and Alicia Ibrahim, who's the Senior Policy Advisor to the Domestic Abuse Commissioner. So it really is worth checking out, and it does have some overlap with today's content. Also, to keep your eyes peeled for our next seminar, which will be coming up in May. That's a joint seminar with the housing team and community care team, and we'll be addressing homelessness and community care in that seminar. So we will also be circulating details of that in due course. But for today's webinar, two of our barristers from Garden Court Chambers will be looking at the public sector equality duty in the housing law context. The PSED is a recurring theme in housing matters, and each new judgment adds another layer of sophistication and complexity to the law in this area. So both Nick and Adrian will be taking stock of the current position of PSED authorities, as well as considering the sorts of points that may arise in future possession, homelessness, and judicial review cases. In particular, today we'll be looking at what housing lawyers can learn from PSED authorities in other areas of law, and discuss possible developments in housing litigation to explore the sorts of points that solicitors among you may wish to raise in your casework. Before we get into the main part of this webinar, we want to promote a new book on the PSED, which is a practical guide to the public sector equality duty in housing law, which was recently published by Nick Bano, who will be speaking this evening. And we're delighted to offer a 10% discount on the book to attendees. And I believe Nick will give details of that in due course. And we've just posted in the chat the discount code as well. So our first speaker this evening is Adrian Marshall. Just a little intro to Adrian. Adrian practices across a range of housing and property law. His practice encompasses many types of possession claims, and he has a range of experience in cases involving mental health or capacity issues, and being instructed by the official solicitor on behalf of protected parties. Adrian's work in housing law has a significant focus on acting for occupiers in complicated antisocial behaviour cases and raising public law defences, which include the PSED. As an experienced property litigator, he also advises on property-related disputes and represents clients in areas such as right to buy, unlawful eviction, harassment, and disrepair. So without further ado, I'm going to hand over to Adrian now. Thank you.
Thank you, Georgie, and good evening. So I am starting with the what I'm going to say is the PSED, the Public Sector Equality Duty in homelessness cases. Because I'm starting, I will start by reminding you of the text of section 149. I'm sure you're all familiar with it, but it's useful to just have it put at the front of the mind. The point about the duty, of course, as I'm sure you're all very familiar with, is that it is not a substantive duty to actually achieve a policy goal. It is a duty to have regard to the policy goal. That policy goal is set out in some detail. The name for that kind of duty is a process duty. But just to remind yourselves here, it is the duty to have due regard to the need to, and this is spelling out the aspects of equality that are specifically covered. So eliminate discrimination, eliminate harassment, eliminate victimization, and any other conduct prohibited by the Act. That's obviously referring to all the wide forms of discrimination which the Equality Act can cover. And B, advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it. And there's some further detail on that. If I just go on to the next slide, which is subsection 3 of section 149, this is where having due regard to the need to advance equality of opportunity is spelled out as meaning. It means due regard to removing or minimizing disadvantages suffered by people who share a relevant protected characteristic. So of course, that's all the relevant protected characteristics that can lead you to have a disadvantage. So have regard to those, and have regard to taking steps to meet the needs of the people with that protected characteristic that are different from the needs of people without it. And again, that's not just different needs of people with disabilities, I think we often tend to think of, but it's any needs which are different arising from or shared by people who have the protected characteristic. Finally, the subsection 4, there is the specific part relating to disabled persons, that meeting the needs that are different means meeting the needs that are different of people who are disabled. It's really clarification if there's any doubt. And then subsection 6 underlines that compliance may involve treating people more favourably than others. And that's, of course, is a feature of what we will frequently be asking people to do. Now, in this talk, I guess I am really thinking about the way that you're approaching reviews under section 202, which may then lead on to appeals under section 204 of the Housing Act 1996. I haven't so much thought in terms of judicial review, although just to be clear, I mean, the points that are being made here will very frequently apply equally to potential judicial reviews, and indeed to interim questions like a potential questions about interim accommodation, which may lead to interim accommodation judicial reviews, which obviously the most frequent form of judicial reviews in homelessness cases, or appeals about accommodation pending appeal under section 204A of the Housing Act 1996. So with that, I've also included here subsection 7. I'm sure you're all familiar with this, that the protected characteristics are much wider than just disability, because obviously the purpose of this equality duty is to bring together the ones which previously existed in other areas and then widen them out. But I think it's all important for us to come back and look at these again, because we have frankly got very used to using public sector equality duty points in very particular kinds of cases, mainly vulnerability, suitability, whether accommodation is reasonable to continue to occupy, and perhaps to a certain degree intentionality. So I want then to turn to how the duty works, and I'm going to start with the first case where it actually gave rise to real consideration and indeed a successful result, which is the case of Peretti and Enfield from 2010. That will be, I think, for many people working in the housing field, the first time that these kinds of equality duties of any kind really came into thinking as something which could lead to challenges which could succeed in cases. At that time, the duty that was actually an issue was the old duty under the Disability Discrimination Act 1995, which was called section 49A. And I've set out here some of the quotes of the kind of key parts of the decision. The issue in that case was that Mr. Peretti had failed to pay the rent, and the question was, and therefore lost his accommodation. What was an issue was whether he had become intentionally homeless as a result. And so the question that is defined there in paragraph 35 as being what the equality duty there gave rise to is, did the review officer fail to make a further inquiry in relation to some feature of the evidence as raised a real possibility that the appellant was disabled, meaning under what was then the Disability Discrimination Act and now is the Equality Act, say in a sense relevant to whether he had acted deliberately within the meaning of section 191. That's obviously the test of somebody becoming intentionally homeless, and part of that can be whether that person acted in good faith. The decision in the case is set out in the next paragraph, and the decision was that there was such a failure because on the facts of that case, the issue is really whether the non-payment of rent was deliberate. There was information from the GP which suggested that there had been a long-term history of depressive illness, and the appellant himself had said that he was subject to a disability on a form as part of the application when asked. And there was an unusual history of failure to pay rent, which was not easily explained. And it was those facts, they were enough to be a real possibility of a disability within the terms of what was then the Disability Discrimination Act, now the Equality Act, that triggered the need to comply with the duty. In that case, what was required was inquiries to obtain information in order to have information to take a decision about whether there was disability which was relevant to the issue which needed to be decided, which was whether non-payment of rent was deliberate and therefore fulfilled the test of becoming homeless intentionally. So that was the way it came in, and it's a good start. But it's important to see that even at that point, what is being said is not simply that it wasn't addressed in reasons, but that there was a substantive part of what the decision maker needed to do that had not been done. So just moving on from Peretti, that establishes where it comes into play. So the lesson in a wider sense is, where is it applicable? Well, it is applicable where there is a protected characteristic which is relevant to the decision in play. I put it as widely as that because it is not simply disability as we tend to think, but it can be all the other factors, age, sex, race, gender reassignment, etc. Going back to what is in subsection 7, the question, and given of course that these will be, everybody will have in some sense a protected characteristic, what one is looking for is an area where the issues are such that the protected characteristic raises an issue relevant to a decision, so relevant to an issue which the decision maker is going to be called on to decide. The threshold, where it's obvious, it'll need to be considered. Where it is raised, it will usually need to be considered. But what you learn from Peretti is that the threshold is lower than that. It is simply that there is a real possibility. That's something important to bear in mind, although as when we're involved as advisors in trying to pursue people's homelessness cases, clearly what we really need to be doing is looking for these issues and trying to raise them wherever possible. And so important to bear in mind that the role of disability and sort of vulnerability of suitability decisions is simply an example of where the duty is at its most obvious, but very much not what the limit of it can be. So that's where it starts. I move on to what the duty actually requires to be considered in the context of a decision about whether somebody is vulnerable and therefore has a priority need under section 189 of the Housing Act, which I'm sure you're all familiar with. And I've started here with quotations from the leading case in that area, which is Hotak and Southwark, which, as you'll all probably remember, was heard with 2 other cases, the important one here being the case of Kanu, which we'll come to in a minute. So the first point I've highlighted is from paragraph 78, where the nature of the duty is being considered, and Neuberger there says some really very familiar things which apply to the way that the duty must be applied in all contexts, which is it's the substance that must be done. It must be done with rigor and with an open mind. So that is, as it were, the opposite of a box ticking exercise, and simply going through the motions. That approach appears in all the case law, and it's not an issue. The point is whether it's actually happened in the particular case. In HOTAC, Lord Neuberger defines the content in terms of there being a sharp focus on 4 aspects: whether the applicant is under a disability or another relevant protected characteristic, the extent of the disability, and in other contexts that will be looking at what the relevant protected characteristic is or its role, the likely effect of the disability when taken together with any other features on the applicant if and when homeless, and then finally whether the applicant is as a result vulnerable. Now the question is what does that mean? But the next paragraph in HOTAC goes on to give some explanation of that as being the first principle of this, which is that what one must be doing when assessing a decision is assessing whether there has been a compliance in substance, that is, rather than form. So what substance means in this context is that the matters which are required to be considered by the duty have been considered, rather than there being simply rather than the form. So we know that, and we'll go on to see that doesn't mean that there needs to be a recitation of the 4 questions set out at paragraph 78 of HOTAC, which I just took you through. The question is rather you audit the decision against that, and you ask whether, insofar as relevant, it actually addressed those. But it also means that in the very frequent situation that we will see that a decision includes some standard reasoning which says that the equality duty has been considered in some way. That standard reasoning, which is not in any way particular to the facts of the case, will not in itself mean there's been compliance. The question will be asking what issues did the duty require to be considered, and was that done in this on the facts of the case? And that emerges from the case heard with HOTAC of Mr. Kanu. So this is at 82 of the decision, where Mr. Kanu's case is rejected on the basis of the equality duty, because it is said that the letter identified the aspects of a disability and addressed them. So substantively it covered the questions that were relevant. That question then was put beyond any doubt in terms of what substantive compliance meant by the decision in 2020 in McMahon and Watford Borough Council, where there was an attempt to argue that what was intended was a sequential or 4-stage test, and that was strongly rejected by Lord Justice Lewison, that clearly shows that we will not succeed if we seek to make arguments saying you didn't follow the test through those questions. What instead we need to do is to look at the substance of it and ask whether the actual decision has covered the issues. So one issue that also arises from McMahon, and perhaps is an issue in Kanu, is whether you can have compliance with the duty without being aware of it. There seems to be there's case law in possession suggesting that whilst it can happen, it's rare. It seems to be suggested in the context of assessing whether somebody is vulnerable and has a priority need, that is more frequent. The reason seems to be clear that you can comply with the duty even without being aware of it, because the nature of the assessment of vulnerability means that you can cover all the issues which substantively you have to consider, but without actually being aware that there was a duty in place. That is importantly in the context of vulnerability, and it's worth bearing in mind that what also emerges from the McMahon case is that one needs to be careful about what aspects of disability are relevant, because when you're assessing whether somebody is disabled under the Equality Act, you're assessing what the effect of an impairment is on them without treatment. Whereas when you're assessing vulnerability, you are assessing the effect of that a condition or impairment may have somebody with treatment that somebody is likely to have. So, and in that context, if there is treatment that a person has and is likely to continue to have, it is clear that the substantive assessment can be taking that into account. There's not a need to go on to assess separately what the effects would be without a treatment, because that, and what we get from that is not a relevant issue. So where have there been successful challenges based on the duty apart from the Peretti case? In McMahon, what was identified as being the feature of those successful cases was that there had been a failure to take specific features of the case into account. And I'll go on to look at that in a bit more detail, but what I think is important to draw from that is that if one wants to make an argument about a failure to comply with this duty, what you really want to be trying to do is to identify what the substantive things that needed to be covered by the duty were and what part of that was not done. And the examples of that we'll go on to consider, which are the Lomax and Cannon cases that Lord Justice Lewison is addressing there, show that how that is being applied. So to get to that, we move through the case of Hack and Hackney, where the content of the duty was looked at in the context of reviewing the suitability of accommodation, and the Justice Briggs in that case set out a series of questions which are clearly related to the questions in HOTAC, but are instead adapting those to say what are the issues that need to be considered where you're addressing suitability. So we start off firstly with the recognition of the impairment and its effect. Secondly, focus on the specific aspects of it which are relevant to the suitability of the accommodation which is being considered. Thirdly, a focus on the consequences of his impairment, and to focus on this both in terms of disadvantages that he might suffer in that accommodation and by comparison with people without those impairments. So those things are important about substantive compliance. And then a focus on his particular need by comparison with people without such impairments, in other words, comparison without disabilities, and then questioning whether the accommodation met those needs. Recognition that he might need to be treated more favourably, again picking up subsection 1496, and then conducting the review of suitability, paying due regard to that. In Mr. Hack's case, he failed because the court found that the review did in fact do that. What was more successful was the case of Lomax. In this case, what was being looked at was not suitability, but whether it was reasonable for Ms. Lomax to continue to occupy bungalow in remote Dorset, quite a long way from the area of Gosport where she wished to move to because she had family. Her situation was that she had both physical and mental health disabilities, and particularly was evidence that her mental health would decline in the accommodation that she was currently in. The court accepted a formulation of these questions, which was obviously from related to both HOTAG and HAT, but is rather more precise. So it accepted the questions being a sharp focus on whether Ms. Lomax was disabled, sharp focus on the extent of her disabilities, a sharp focus on the likely effect of her, as long as she continued to occupy the property. So importantly, what effect would her disabilities have on her in the property that she would be left in if she was not found to be homeless, and a focus on her particular needs in relation to accommodation, which come from the disability, whether the accommodation meets those, and then a comparison between her needs and the needs of people without her disabilities. And again, recognition that she might need to be treated more favourably than others without her disabilities. The case succeeded because they had failed to do that. What they had done was they had compared her circumstances with the general housing conditions in Gosport. The difficulty with that is what they had not done was the comparative exercise of her as a person with disabilities, and the difference that she therefore had between her circumstances and those without her disabilities, and also very clearly the adverse impact on her, the disadvantages of remaining in the accommodation, which in that case there was evidence that her mental health was declining. So I would say it's important points to carry forward into other cases, to review it against those and to think very much in terms of adverse impact. A further case which is in a similar vein where the challenge succeeds is the case of Cannon and Newham. In that case, the issue the background was that there had been an assessment which said that the accommodation was not suitable and that there was a need for alternative accommodation, in fact in the context of priority for permanent accommodation on the housing register, and it was held that there's a failure to understand that properly. But it was also said that the treatment of disability was wrong because the severe pain was downgraded, and therefore and to being uncomfortable and inconvenient. That, it was said, was not a sharp focus on Mr. Cannon's disability, its extent or its likely effect. So what is being said there is that by downgrading the effect of the symptoms as set out in the medical evidence, there's a failure to consider the adverse impact arising from the disability. And then in paragraph 23, there's a similar finding that the decision was unlawful, similar to Lomax, because the comparison made to the generality of people living in the area is not adequate when what one has to compare is the people with disabilities with people without those disabilities. There's one further case that I want to deal with, which I think it is the shows a limit to the case. Now, this is Biden and Waverley Borough Council from last year. The issue in that case, so Ms. Biden was represented by very senior public law counsel. It's not entirely clear how the issue came down to this, but the issue which is defined as being where the public sector equality duty came down to is said at paragraph 43 to be should the reviewing officer, Ms. Donaldson, have made inquiries about the effect the incidence of gender reassignment hate crime in the area where Mrs. Biden was to be offered accommodation to the lesbian, gay, bisexual and transgender liaison officer rather than the local police community safety officer. It's not entirely clear why it came down to that. This was clearly a suggestion of adverse impact to Ms. Biden of the location of the accommodation, as she was a trans woman. So this is the gender reassignment limb of protected characteristics. On the facts, it seems that the accommodation was very close to the accommodation which she had previously rented, without apparent complaint. And so in that case, the challenge fails because it is said that making inquiries of the local PCSO about whether there was, a significant concern of incidents of gender reassignment hate crime, that was sufficient. There wasn't a need to go to this specialist liaison officer. That seems to be a fairly sort of pure question about whether about the kind of scrutiny given to decisions, but it's important to note that there was no doubt that the inquiries were made into the subject, and when the decision came to be assessed, one could see from paragraph 59 where the decision is upheld that the framework of review is to again look at what the content of the decision is as compared against a framework of questions based on the HAC framework of what needs to be covered. So that again suggests that what we need to do, and that's being applied to the gender reassignment framework, and really that's just clearly the route for us to do that, is to map our complaint onto the issues that need to be covered. So where does that leave us in terms of future cases? Well, I mean, as I mentioned from the beginning, one would hope that we will go to a use of a wider range of protected characteristics in our challenges. Biden's example of gender reassignment, which was not successful on the facts of that case, but in other circumstances it may well be, and it is not difficult to think of circumstances where due regard would not be had to the effects and issues arising from gender reassignment. But equally, a very obvious one is gender, and that brings on to the second point that to raise here, the wide-ranging nature of the duty, as in having regard to the need to eliminate discrimination and advance equality of opportunity, does lend itself to putting forward arguments where the structural effects of discrimination are brought out in individual decisions. So if one can look at the way an individual set of circumstances affects your client and say this is part of adverse structural effects of discrimination, these are points that we should be putting forward, because if we don't put them forward, it's clearly very hard for us to then pursue them in appeals or in judicial reviews, because it is the point before that where these issues are raised that is really going to set up challenges which are likely to be successful. Next, and obviously a related point, is focusing on identifying adverse impact arising from protected characteristics and requiring that to be assessed. That, I would suggest, if we want to look at new issues, it is the area to cover. I'd mention at this point the recent case of Zaman and Waltham Forest, which I'm sure many of you will be familiar with. That was a case where it was decided that the operation of an outer borough temporary accommodation policy was not lawful. But one could well imagine circumstances where the adverse impact on the basis of protected characteristics, gender being the obvious one, could be something which one could look to be considered. One puts forward the adverse impact, and that adverse impact also relates to your client, and one then looks to see whether one can challenge the consideration of it. The final two bullet points here. Most of the cases so far have covered areas where there's been a fairly clear alignment of the issues arising from the public sector equality duty, for example, discrimination, and the issue in the decision. But there really is no reason why it couldn't be relevant where there isn't a clear alignment, and we should really be trying to keep that in mind at the point of doing reviews or putting forward letters before claim and judicial review, to raise these points and therefore require them to be considered. When we're then assessing whether decisions have actually covered these, what does also appear to be the case is that using a kind of developing a framework of issues, using the kinds of frameworks that were seen in HOTAC and HAC, adapted to the issues in the actual case, is the way to assess substantive compliance, and probably the way to the way to see when there is a case that can succeed, because it is to look for a gap in the coverage of the issue where from the case law it looks like we can succeed. The final point I want to mention is in relation to challenges to policies and procedures, and that this is arising from the Al-Kundi case, and I should say I'm grateful to a passage in Nick's book which deals with this. In that case, at first instance, there was a finding that Birmingham's policy in terms of the way it's provided accommodation for people for whom a duty had been found was in breach of the public sector equality duty. It was found that it didn't show that there had been regard to the impact that system had on disabled people. That was a challenge by judicial review, and the reason why that's a judicial review is because it's a failure to provide accommodation. It's a failure to make offers, and therefore there wasn't a challenge that could go for an appeal. Clearly, we can challenge policies by judicial review where circumstances arise, but the point that is made clear from the final paragraph of the decision in Zolomezu is that because we can rely on any points of law arising from a decision under appeal, that's the review decision under section 202, that also means that we can challenge the legality of policies applied in our clients' cases. So we absolutely want to be looking at both written policies and also what there frequently are, which is procedures which are applied more generally, and looking to see whether those can be considered to give rise to public sector equality duty challenges, and again, not just on the basis of disability, on the basis of race, gender, and anything else that we can think of. So that ends my talk, and I will now hand over to Nick.
Just going to give a little intro for Nick's talk. So thank you so much, Adrian. We do have some questions coming in. That was super useful. And we've seen that whilst there is a comprehensive body of case law concerning disability, poor housing outcomes in respect of other protected characteristics, particularly race and sex, is somewhat of an under-examined issue. And at Garden Court, our housing team is keen to lead the discussion about the role that the PSED can play in challenging those structural issues, those procedural problems with procedure and policies in local authorities. So without further ado, I'll be handing over to Nick. Nick specialises in representing homeless people, residential occupiers, and destitute and migrant households in both public and private law disputes. He's acted in the most important housing law cases in recent years, and the legal directories consistently recognise his expertise in this field, as well as his attentiveness and commitment to his clients. Nick has a particular specialism in cases where social elements overlap with equality and discrimination, and the key areas that he's been in, the key cases that he's been instructed on, some of which were mentioned, include TM, Forward and Aldwick, and Quadrant and Patrick. So yeah, Nick's also going to be telling you about his book, I'm sure, and here are his slides. Thank you, Nick.
That's great. Thanks, Georgie, and thanks, Adrian, and thanks to everyone for coming. Hopefully you can see my slides and that someone will shout at me if you can't. It's brilliant to see so many familiar names in the audience, and please do avail yourself of the Friends discount. I think it's been posted in the chat. I'm going to do two things on possession. I'm going to go through the nuts and bolts, the stuff we ought to know, and just make sure that we're all up to speed, because the possession aspect of the PSED is easily forgotten. It's the unglamorous relative of homelessness, but it's important, and it's important that we remember what the key cases say. And then after that, I'll come on to think, as Adrian's done, about some of the future cases, some of the more adventurous points that we may want to run in the future. And I absolutely agree with what Adrian says and with what Georgie's just alluded to about the need to think about other protected characteristics, particularly race. It's a big issue in the press at the moment, and it needs to be a big issue in the courts as well. So moving on. What I've got here are the 6 cases that we probably ought to know, if not offhand, then somewhere in the shallowest recesses of our memory, the sorts of cases that we need to be able to reach for if we're having a row with an opponent or with a judge, just to make sure that we're on top of the law. TM is the most recent PSED possession case, and it's a treat for us, of course, because the tenant actually won. I think we're used to being told over and over again by the senior courts that, of course, this is a terribly important duty, and of course, nothing that they're about to say undermine its importance before the case goes on to lose. But TM is a good case because it was successful to the tenant. It was, of course, very sensitive on its facts, but it's a good case nonetheless. Patrick and London and Quadrant is useful because the High Court, Mr. Justice Turner, takes the trouble to give some sort of bullet points about how the PSED is supposed to be complied with in the possession context. So if you want a quick checklist about what the PSED is all about in possession claims, Patrick's the place to look. And it's been approved, or at least cited with approval by the Court of Appeal. So it's the starting point for how it works here. On the facts of the case, which we'll come on to in a minute, it was a very late medical evidence case where the tenant turned up 2 or 3 days before the hearing with a medical report, and His Honour Judge Sagerson gave no store to the PSED, and his judgment was upheld on appeal. The next case is Forward and Aldwick, which is a key case on the PSED generally, which shows that even humble housing lawyers like us can make a splash outside of our own little pond. And it's about the approach to remedy when the courts have found a breach of the PSED. And this is the sort of chink in the armour of the legislation that the courts have been quite clear that even where you get over the hurdle of establishing a breach, sometimes the courts can say, so what, it doesn't matter on the facts of the case. And Forward is where we get the principles in respect of that. It's also the Court of Appeal case where they cite Patrick with approval. So if you want to be sure that the Patrick guidance is good law, you find your evidence for that in Forward. Bracking is an old case, but all of the subsequent authorities in every field of law treat it as the sort of core text of the principles of the PSED. So when we're thinking outside the box, when we're reaching back for principles that maybe aren't particularly familiar to us as housing lawyers, but which we want to play around with, it's bracking that we turn to. we've got to treat it with a little bit of caution, because the courts have been very clear in a case called Powell that context is everything when it comes to the PSED, and we can't just go to cases like Bracking, steal the nice phrases and dicta and apply them in the possession case, because Bracking was about a matter of national policy, and the courts have been very clear that you are doing a different thing when you're deciding to evict an individual tenant and when you're deciding a matter of national policy. So you've got to treat it with some caution, but it's where we get many of these key ideas from, and it's worth having a look at. And finally, is a county court case called Rosebery and Williams, which isn't necessarily authoritative, although it's a judgment of Judge Luba Casey. But what's good about it is that it's a recent case. It's a very thorough case, and it's a case where the PSED succeeded in very clear terms. So it's good as a sort of working example. If you've got a judge or opponent who says, well, you know, it doesn't really make much difference in practice, does it? Rosebery's a good case to turn to. The first thing we need to do as housing lawyers is make sure that the duty is to be complied with. We need to raise something that forces the landlord to comply with Section 149. Because of course, in disability cases, there's authority that it won't apply if it has been established that the tenant is not disabled. Adrian mentioned those sort of grey cases about, well, maybe they're disabled. Is there a real possibility of disability where the PSED might apply? But of course, we want to be on as firm ground as possible and say, well, no, there is a disability here. You've got to comply. You've got to do your assessment. So the first thing we have to do when we're thinking about defending a case is look at what the disability is. And if we can look backwards through the documents and establish that they already knew about the disability, they've known all along, then we're on very, very firm ground indeed. And I'm sure you see this a lot, where the tenant's been emailing their housing officer, or there's been an allocation which is involved in assessment, and the landlord's known all along that there is a disability issue here. And that's the gold standard. That's what we're digging around for when we're looking at cases at the very start. If we haven't got that, or if it's something you've discovered yourself in taking instructions from the client, or if it's just something that's new, then what we need to do is raise the disability ourselves, or other relevant characteristic. I'm going to focus on disability for the time being. But if we can't prove that the landlord knew it, then it's down to us to say, well, there is a disability. And we can do that by correspondence, we can do that by medical evidence, which I'll talk about in a minute, or we can do it by filing a defence. But ideally, for the purpose of drafting the defence, it's best to do it as early as we possibly can. So if there's any possibility of writing to the landlord at an early stage and saying, look, I'm sure you're aware there is a disability here, this is what the disability is, then that puts us on a firm footing when it comes to drafting our defence and getting over that first hearing stage. But that by itself isn't enough, because not every disability is going to be relevant. Just saying someone is disabled won't raise the PSED to the extent that it's going to amount to a defence, and it has to matter somehow. And I've given two examples there from the reported cases at the opposite ends of the scale. In Forward, the disability didn't matter, and in TM it really did. In Forward, what Mr. Forward was saying was, well, the reason there's been antisocial behaviour is that I'm a victim of cuckooing, and I'm a victim of cuckooing because I've got mental health problems. And when it came to trial, he couldn't prove his mental health problems. He could only prove physical health problems. So while there was a breach of the PSED in respect of his physical health problems, that didn't matter because his defence was all about psychiatric disability, which he couldn't prove. So despite an acknowledged disability, the PSED was irrelevant on the facts of the case. TM, completely the opposite. This was a case of someone who was living in what was effectively a care home. He lacked capacity. His antisocial behaviour, he'd attacked one of his carers, was a manifestation of his disability. So the reason for the eviction was very, very closely wrapped up with his disability. And it was a much clearer case on its facts. But of course, what his lawyers had to do was satisfy the landlord of the link before the PSED was triggered and before an assessment could take place. And what our job is it's to front load the case. It's to create a disaster down the line for the landlord, well, ideally to persuade them to drop the proceedings, but if they won't drop the proceedings, to see if they are going to comply with the PSED in the meantime. And the way we do that is by giving them as little wiggle room as possible. And Adrian's explained in the homelessness context how useful it is to have those representations at an early stage. Exactly the same in possession. There's a really nice line from, I think it's the Cannon case, where Lord Justice Lewison says that compliance with the PSED, citing the words of the statute and citing HOTAC and all the other cases, is not a defensive ritual incantation. It's no substitute for actually doing the job. A public sector worker has got to actually grasp the nettle and think really carefully, think really seriously about the disability issue. So when we put it in really, really striking terms and force them to think about it, it's much, much harder for them to say, yeah, I thought about it, it doesn't matter, don't worry about it. So front loading a case is really, really important. And that's one of the first things that we'll have to do when we first take instructions. When I came down to doing the book, I got in a terrible panic about the medical evidence issue, because there's confusion in the case law. There's the Patrick case, which I mentioned already. And as I said, it came before Judge Sagerson for a Part 55 hearing. And very shortly beforehand, there'd been medical evidence. And the judge said, well, that's too little too late. They don't really have to do very much because your medical evidence is so late. And the High Court agreed. The court said that the evidence was so late that the landlord didn't actually need to do a formal assessment. By simply taking a view that it was appropriate to continue the proceedings, they had complied, notwithstanding the provision of new medical evidence. But on the other hand, we have cases like TM, where there's a very similar chronology. An expert report was served at around the same time, just before a Part 55 hearing. And in TM, the Court of Appeal hit the roof and said, you know, you needed to reconsider very, very carefully at this point whether you were going to evict a disabled tenant. TM's a later case and it's a Court of Appeal case, so it may no longer be good law that if you raise 11th hour medical evidence, there's a less thorough PSED assessment. But it's important not to risk it. If we can get medical evidence in, it's absolutely worthwhile. It makes things much easier, much neater. There's other cases from other contexts. I've cited the case of Rowley there, which I'll highlight because if you've not read it, it was a challenge to the coronavirus briefings, the daily briefings, which I'm sure we all remember so fondly. There was a dispute about provision for people with deafness and what provision ought to be made for signing or subtitling the briefings. And what's good about the case is that the litigant took every point going. There was breach of the PSED, there was Section 15 discrimination, there was Section 19 discrimination, there was failure to make reasonable adjustments. And it's Mr. Justice Fordham, and he goes through it really, really thoroughly and really, really carefully. And it's a really good primer on the sort of Equality Act issues we see every day. And if you want to be really up to speed on the law, then that's the case to read. I really recommend it. But what he said about the PSED and with late evidence was that the standards of scrutiny remain the same, whether the assessment is produced at the door of the court, as it had been in the Rowley case, or whether it had been produced at the very start, which ideally is what public authorities are supposed to do. If, and I know this happens, of course it does, if we're struggling to get medical evidence at an early stage, what you can try and do is shift the burden onto the landlord, because in some contexts, the PSED imposes a duty of inquiry. And I've quoted the Shake case there, Shake and Lambeth, which is a challenge to the low traffic neighbourhoods in South London. But again, it's one of those principles that we probably can read across, not least because in the Forward case on the first appeal in the High Court, Mrs. Justice Shima Grubb also made the point that in some contexts, the PSED includes a duty of inquiry. So it's fairly safe to say there's a duty of inquiry in possession, but it's second best. If you can get your own medical evidence, of course, that's much better, because we want to get the landlord into a box where they've got to really face up to the fact that they're evicting a disabled tenant, and they've got to do that properly. So that's medical evidence. Something that's important now, particularly post TM, is the overlap between the PSED and discrimination proper. Because until TM, what used to happen all the time was I'd get opponents who would say, well, they go hand in hand. If you lose on discrimination, you don't have a PSED case. They can't work independently. We now know that's wrong because TM succeeded. It's particularly clear if you read the High Court judgment, because in the High Court, there was an appeal both on a PSED point and on a discrimination point, and both failed. So by the time we got to the Court of Appeal, the PSED was the last point standing. There was nothing else. And the appeal was not only allowed, but the Court of Appeal actually dismissed the whole claim for a breach of the PSED. So we now know with absolute certainty that you can run it on its own. Don't panic if your discrimination point fails. Obviously, it's stronger if your discrimination point succeeds, but you can run it on its own. And it's worth saying that they do work well together. There's a case called Cole, which is a key case about direct discrimination and inadequate provision for women. And what Baroness Hale suggested, didn't necessarily say, but suggested in Cole, was that it's difficult for landlords to prove proportionality, because of course the duty's on them if they haven't complied with the PSED. It's very, very difficult for them to say no lesser measure will do, this is proportionate, if they haven't done a thorough assessment under section 149. And that's been picked up in a couple of subsequent cases. There's a case called Hussein, an immigration case as well. So it's worth making that point as well, that absent a very good PSED assessment, they're going to struggle on proportionality. One of the big issues that came up with TM is retrospective compliance. The PSED is a bit odd because we plead it right at the start in the defence. But by the time we get to the trial, everything's totally different. There will have been new medical evidence, there will have been an evolving set of factual circumstances, maybe the behaviour's got better, maybe it's got worse, but whatever happens, by the time the landlord gets to trial, they know an awful lot more than they did at the start of the case. So necessarily their PSED assessment is going to have to be a bit different. And the question is how we deal with that, given that they're probably going to recomply. What happened in TM was the case was dismissed because of a failure to recomply when they got new medical evidence. There was a capacity report. It said that the tenant lacks capacity, he's very disabled. And the breach was failure to reassess at that point. So any landlord, certainly any landlord solicitor worth their salt, is going to be saying, you need to recomply at some point before the trial. It can't be so early that you won't take everything relevant into account. It can't be so late that it would be unfair to spring it on the defendant. But by the time you get to trial, you're probably going to need to produce the new assessment, which is different from the one that's attacked in the defence. So we're shooting at this moving target. We don't necessarily know what the assessment's going to look like by the time we plead the case. And how do we deal with that? It's probably lawful to recomply late in light of new evidence. I say probably because although TM was all about this case, in fact, it was per incuriam because the appeal was allowed on a different point, but it's probably fair to say you can comply late. But something that it's important to note is that in other cases, particularly in other contexts, the courts have suggested that ex post facto PSED assessments should be subject to greater scrutiny. Because all the case law says it's supposed to be, it's supposed to inform the decision. It's not supposed to be a rearguard action. By the time they get to trial, landlords will have incurred significant costs. They'll have a whole litigation strategy, and they won't want to undermine their own decisions by complying with the PSED late. So the authorities suggest, but don't necessarily establish, that the courts ought to pay much, much more attention to retrospective compliance than to an assessment that was carried out at the start of the case. And you know, we can make some headway there by pointing out that it needed to be more thorough than it is, or that the initial breach, if there was a breach that was then corrected, has ongoing consequences, because this is what the TM case was all about. It was dismissed, or rather the appeal was allowed because having been a breach, it had never been corrected even by the time of the appeal. And that had very, very serious consequences for TM because he lacked capacity, He'd been dragged through these years-long court proceedings, a multi-track trial, an appeal and a second appeal, and he couldn't even participate. And he was at risk of losing his home the whole time. So there were serious consequences for TM flowing from a breach that had happened around about the time of a Part 55 hearing years earlier. The reason this is important is because it's really, really valuable for final witness statements, for pre-trial witness statements, because this is the way in which, well, it's the only way in which we can establish the materiality of any breach. So what I think is helpful to do is assume you're going to win on a PSED point. What has it meant for your client? So has the litigation been particularly stressful? All litigation is extremely stressful, so that's probably an easy point to make. Has it exacerbated any disabilities? Has it made their symptoms worse by the stress and the horror and having to think very carefully about their disability and having to go to court? Is that an impact of the breach? Has it actually made any ASB worse? Because we're probably all familiar with, by the time we get to trial, neighbours hardly being on speaking terms with each other, and the stress of litigation almost certainly feeds into that. And if the litigation has been pursued in breach of the PSED, then we can try and say, well, there really were consequences here. And it's helpful to say, although it's not necessarily on us to say, what we think the landlord should have done differently, what the landlord could or should have done differently if they'd properly understood the disability. And the Rosebery case is really helpful here because Judge Luber makes the point that this was such an anxious issue, this was such a difficult neighbourhood dispute that they should have got specialised training for their housing staff. And that's probably something worth raising in correspondence throughout the proceedings, something worth raising in witness statements. You know, what training does the landlord have about this particular disability, and should there have been more? Moving on from the established law and what we already know, I wanted to talk about where we go from here. And I've been thinking about this a lot recently, partly because it's been in the press a lot, and partly because I seem to have an awful lot of cases where you start it off as a PSED discrimination defence and say there's a mental health issue. And by the time you get to trial, you realise that actually there's also a race issue. There still exists racial tensions in an awful lot of social housing. People are still subject to bullying. People are still subject to judgmental attitudes from their neighbours and from their landlords. And it's not uncommon, I find, to get to court and for the case to take on a completely different sort of complexion, if I can use that word, about the underlying disputes. And I think what would be helpful is to explore these issues earlier so that they can be pleaded, because you don't want to go into a trial saying, look, I know the defence is all about disability. Actually, it's going to be, the trial is going to be about race. And it's an important point, even if there isn't racial discrimination proper, because the Act is very clear that the prohibited conduct is harassment, victimization, and any other conduct that is prohibited under this Act. So if your client has been subject to racial comments from their neighbours, if your client's been subjected to bullying or harassment or taunts or jibes, the landlord must have due regard to the need to eliminate it. That's exactly what section 1491 says. And the same would easily go for sexuality or for gender reassignment or for sex or anything of that nature. If there has been the sort of very unpleasant neighbour dispute that has led to or informed or even formed the environment of the antisocial behaviour, section 149, at least in theory, obliges the landlord to have due regard to the need to eliminate that behaviour. And of course, that should manifest in the way in which they decide to manage ASB against our clients. This happened in a case called Guinness in England, which is an early PSED case, a first instance case, a judgment of Judge Bloom. It wasn't, the PSED wasn't pleaded as race in that case, but what happened was that the racial bullying emerged during the trial. And I think it just goes to show that the commonness of it, rather than saying that, I'm not saying that this case establishes the law, but it does happen anecdotally. And similarly, there was a case on Nearly Legal a couple of years ago that you might remember called TJ and London and Quadrant, which was a misrepresentation case about a tenant who moved into a flat having specifically asked, is there any problem with racial abuse? the landlord said no, and it turned out that the upstairs neighbour had been very, very severely abusing the previous racialized neighbour for years beforehand. So of course this stuff happens, and you know, it's sort of down to us to keep an eye on it. We know what landlords might say. They might say this is a stretch, this is an outrage, this is nonsense, this isn't what the PSED is designed to do. All I'd say about that is that the first PSED under the Race Relations Act was created in response to the Macpherson report into the death of Stephen Lawrence, and the first official recognition of institutionalized racism in the Metropolitan Police. And what it was designed to do was to move from a reactive system of managing institutional racism to a proactive one. So it's entirely appropriate, I think, that we use it in the context of social housing, where this remains a very serious issue, particularly because there are extraordinarily differentiated housing outcomes for racialized people. Some headlines here about, well, proving how right this point is, both about race and disability. First one from My London. Clarion accuses Londoners of making it difficult for tradespeople to complete repairs so they can claim more money in damages. I'm sure anyone in this room who has been anywhere near a disrepair case file will be very surprised to hear this, because of course our clients more often than not are desperate for works to be done, and it's the landlord's fault. They call when they're not in, they fail to make appointments, and the idea that you blame people is sort of an outrage. But Susan Clinton, named there, who is, by the way, the head of housing at Clarion, which is Britain's largest housing association, blamed people's chaotic lifestyles for delaying works being done. I mean, obviously our clients do have chaotic lifestyles, but that's not deliberate. It's certainly not a tactic. And I think what's really striking about this is that whenever we litigate PSED defences, the landlord will come up with an assessment and a policy that says, we take disability extremely seriously. We are very, very alert to the needs of people with disabilities. We are sensitive to them. We want the right outcome for them, and we're highly trained. And this is their boss. She's saying it at a public meeting at Lewisham Council, and it's absolutely extraordinary. It makes very, very good material for correspondence. It makes very good material for cross-examination. And if there's any issue about whether landlords like Clarion have adequate policies and have the right attitudes towards dealing with disability sensitively, then this is the sort of thing I think we ought to be showing them. The next one is from Peter Apps, whose book on Grenfell, by the way, is excellent and highly, highly recommended to all of you. And I'm sorry to raise this during Ramadan, but it's an important point. He said, shocked to hear a source say that when landlords talk about ritual bathing in the context of damp, it's a reference to Muslim families washing hands, face and feet before prayers. If that is the case, it's about the most ignorant, xenophobic and disgusting thing I've ever heard. Well, he's absolutely right, of course. This hit sort of national headlines when it turned out that Rochdale Borough-wide Housing had used this as a pretext for failing to repair Awab Ishaq's parents' home. I know Giles Peaker has said on Nearly Legal that it's very common. It's outrageous, and it's more grist for the mill when we say that there are very serious and anxious issues of race in social housing, and that we ought to be using the PSED to tackle them. And the final one is a headline from yesterday. Social landlords in England says mold was acceptable in refugee homes, and it's the same landlord, Rochdale Borough-wide Housing. A social landlord claims that refugee tenants were lucky to have a roof over their heads, and that mold was acceptable in their homes, and investigation has found. So I'm not making it up when I say that there are these difficult issues of race and housing. I'm not being adventurous when I say that we ought to be using the PSED to tackle this. This is exactly what it's for, and it's really down to us to push it. Borrowing tactics from elsewhere, lots of you will have done judicial reviews on policies and more structural things, and one of the things that sometimes comes up there is the impact of policies. What is the broader impact of decisions? you know, in the possession context, we can think of things like, is your absolute and mandatory grounds policy having a disproportionate impact on people with disabilities? And if the landlord says, I don't know, that in and of itself might amount to a breach of the PSED, because as well as the inquiries point, the PSED can include a monitoring duty. I cited the Khalsa Academies Trust case there, which is a case about funding for religious schools, but more familiar to us will be things like allocation decisions, where various judges have said, if you've got an allocation scheme, the PSED requires you to think about and monitor how it affects protected groups. So if a landlord says, well, we don't know, if you're running a discrimination defense and the landlord says, we don't know, one of the things you can say is, well, why aren't you monitoring it? Can you tell us, can you find out how many people you've evicted under mandatory grounds in the last 3 years? How many of them have declared a disability? And maybe we should start thinking about this more seriously. Similarly, with rent recovery or evictions and benefits cap people, we know from the Supreme Court there was a concession in one of the benefits cap challenges that the benefits cap itself is more likely to affect women because they're more likely to be single parents to children. So if a landlord is taking aggressive rent arrears recovery policy, is the landlord adequately monitoring the effect that that's having on women as opposed to men? That's a respect in which the PSED can be really useful, and I think it's underused in the possession context. And the final slide, you'll be glad to know, the impact of an eviction. To an extent, we're already doing this in the Dodana case 2 or 3 years ago now. This was the successful basis of the PSED defence. The landlord hadn't adequately considered the effect that the eviction would have on a person who was disabled. But we can go broader than disability. And I think we can think more creatively about the different housing outcomes that people face because of the well-documented disadvantage in the private rented sector. No DSS, and you'll note that my colleague Tessa and Shelter have been working hard on this, will have a disproportionate impact on pretty much every protected group, because lots of people with protected characteristics are more likely to claim housing benefits than those without. There's academic research that shows that people from Black and minoritized backgrounds are significantly more likely to face homelessness and discrimination by private sector landlords. And indeed, the government's own assessment of its right to rent scheme, which was published a couple of months ago, showed that 1 in 5 of landlords admitted to being aware of racial discrimination in the private letting area. So if we go back to that first slide about giving them the material to paint them into a corner and give them something to think about, if we're saying all along throughout the litigation that my client is going to fare incredibly badly in the private sector because of this, then they're at least going to have to consider that. So there's important work to be done here. We live in a system, as I say, with extraordinarily disproportionate housing outcomes as far as race and disability and gender and sexuality and gender reassignment are concerned. And it's part of our job as legal aid lawyers to push back against that and see if we can't use the PSED to make the world something of a fairer place. And I will leave it there.
Thank you so much, Nick. That was super practical and a really broad look at how we can go ahead and use the PSED. So we've got a few questions on the chat and some directly. The second question on the Q&A, I think I'm going to frame it in terms of something I wanted to ask. So how do we go about pleading the PSED when the issue is adjacent to a protected characteristic? So we've got the example in the Q&A of single parent households. So obviously being a single parent isn't a protected characteristic, but but your gender is. Also, we have families where accommodation is unsuitable for trafficking concerns or child criminal exploitation. Again, being a victim of trafficking isn't a protected characteristic, but race might be, and you might be more vulnerable to trafficking and exploitation because of your race, which might make a certain borough unsuitable. So in those kind of cases, how would you go about showing the link and thereafter pleading the PSED?
Would you like me to answer that now?
Please.
Sure. Well, Adrian was right to point out that the list of protected characteristics, because of course we're stuck with them. It's not Article 14, so we can't do that creative thing of designing our own bespoke other status. We're stuck with the protected characteristics. So I think you do it in stages. You say it's well established that the PSED requires you to have regard to the impact of the decision. So what is the impact going to be on my tenant? It's well established that sex is a relevant protected characteristic, for example, and it's well established that the benefits cap has a disproportionate impact on women. So you have to sort of join those dots and say, what do you think about that, landlord? I mean, it's a due regard duty, so all they have to do is think about it, but the least we can do is force them to, I think.
Did you have anything to add, Adrian?
Sorry, no, I mean, that's Nick's put it actually much better than I could.
Thank you very much. So the second question, I think we touched on it, you touched on it, especially Nick, in talking about how witnesses, especially at trial, where there's allegations of antisocial behaviour, it might come to the forefront that actually there's racism going on, and that's an underlying cause of the antisocial behaviour. But beyond being that being a defence, is it only a defence in the PSED sense, or is there a separate kind of almost harassment claim there, or would it all be incorporated into the PSED arguments?
Well, if the landlord themselves was doing it, then your defence would just be discrimination. I don't think the harassment will work as a defence. But yeah, so it would have to be through the lens of the PSED. You would have to say you have to have due regard to the need to eliminate harassment. Therefore, if there has been some, you need to think very, very carefully indeed about how you're managing this ASB. So it's not open and shut. You know, it's not neat, but that's how you have to frame it, I think.
Anything to add, Adrian?
No.
The last question was, please do keep adding them if you do have any more in the Q&A. Practical tips for pleading the PSED in a defence. I know one of you mentioned front loading it, but just as a matter of form, how would you go about it?
It's a really good question, and it's something I struggle with a lot in the book, because I think it's one of those things that really does have to be tailored to the fact of the case. I think a lot of the time what we're worried about is giving the game away, and by very precisely criticising the way in which the landlord has failed to comply with the PSED, we give them a gift and say, look, this is the way in which you have to comply with it, and please do that, and then we rob ourselves of a defence. I'm not hugely worried about that, partly because of the point I made earlier about the need to scrutinise more carefully ex post facto assessments, partly because these PSED defences aren't usually easy to get off the ground anyway, and district judges tend to thank you for pleadings that are clear and precise rather than for pleadings that are muddled. But one thing I would always recommend is covering yourself and saying, if there is any attempt at future compliance, we reserve the right to attack the legality of that.
I would add something to. I mean, I agree with what Nick says, but I think you you definitely do want to try and identify, in some sense, what it is, because there is far too much pleading around that judges see that is just completely generalised and doesn't really tell them a lot what your complaint is. So, I mean, I think it's good to keep things broad enough that they can potentially encapsulate developments, because you, as Nick pointed out, how something looks at the stage of trial will be quite different. But if a judge can't pick up what kinds of complaint you're making, then you're you're sort of setting yourselves up for the kind of global 100 the Labour kind of problem, where they just think that you've raised something without thinking about what it is, and therefore it's not something they think should go to trial.
Thank you very much to both of you, and thank you for everyone who attended this evening. As I said, we have the links to our previous seminars and our private videos in the group chat, as well as the all-important code for your discount on next book. And I hope you found this evening useful. A massive thanks to Adrian and Nick for their resources that they've provided this evening, which will be emailed round to everyone. And I hope you have a good evening filled with thoughts of the PSED.